It's been a week since we first learned that Blake Lively had settled her lawsuit with the Wayfarer parties, but there are still a couple of outstanding issues, including Jennifer Abel's indemnification claim against Jonesworks and Blake Lively's 47.1 request for fees. We know now that both parties, Blake Lively and the Wayfarer parties, including Justin Baldoni, they cannot appeal the decision on the dismissal of their claims. Blake Lively had voluntarily dismissed 2 claims earlier on. The judge then dismissed 10 of her 13 remaining claims, and she decided to drop the following 3 in this settlement. She cannot appeal the dismissal of her 10 claims, and Justin Baldoni cannot appeal the dismissal of his lawsuit that the judge had ruled back in June 2025. The parties walked away with Blake Lively receiving $0 from the Wayfarer parties and no NDAs in place, meaning that the Wayfarer parties and Blake Lively can go out and tell their sides of the story. I had a chance to sit down with one of Justin Baldoni's attorneys, Kevin Fritz, to talk more about that. If you haven't seen it, I'll post a link in the comments below. But the one remaining issue that generated a lot of buzz last week was that 47.1 claim for fees in the dismissed Wayfarer case. So Justin Baldoni's lawsuit that was dismissed is the relevant case here, not Blake Lively's lawsuit, her affirmative claims, which were settled. Now, the weird thing about this was that Blake Lively was wanting to litigate this further after settling her case, which I understand is not typical and that she has a lot of hurdles she would have to get over in order to have this motion granted. But her attorneys wrote to the judge last week asking for leave to file additional briefing on the issue. The judge has now declined that request. You can see in the one-line memo endorsement he wrote here, the court does not require additional briefing at this time. And to me, it seems kind of bizarre to think that they should still be fighting this stuff in court when everything has been dismissed and settled. And there are a lot of substantive things that would go into granting a motion like this that never played out in court. Here's what Blake Lively's attorney said to the judge when they had asked for additional briefing on this issue. It says, the parties have fully and finally resolved all claims except one. The one remaining claim is Ms. Lively's claim for attorney's fees and costs, compensatory damage, automatically tripled by statute, so 3 times compensatory damages, and punitive damages under California Civil Code Section 47.1, which the parties have submitted to this court to adjudicate with no right of appeal. So whatever the judge decides, they won't appeal it. Section 47.1 imposes severe and mandatory penalties against any party who files unsuccessful retaliatory defamation actions against sexual harassment and retaliation complainants. Under Section 47.1, any communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination, including retaliation, is privileged, so long as the speaker has or at any time had a reasonable basis to file a complaint of sexual harassment or discrimination, whether the complaint is or was filed or not. So the problem with this is their suit was not found to have been retaliatory. And the judge kind of alluded to this in their last hearing. I unfortunately didn't get to attend, but a couple of people were there. And the judge didn't appear to be buying it, that their actions were definitely retaliatory in nature. He reminded Blake Lively's attorney that he dismissed their lawsuit on technical grounds, which is kind of funny because they try to say that Blake Lively's claims weren't baseless because they were only dismissed on technical grounds. So you kind of got to pick a lane on that one. Either dismissing things on technical grounds does not mean that the claims were illegitimate, or it does, but you got to pick one or the other. Section 47.1 was designed to ensure that individuals subjected to sexual harassment or retaliation can share their experience with courts, agencies, the press, and others without fear of suit. The problem, of course, being her sexual harassment claims were thrown out, so that was she was never shown to have been sexually harassed. And she was also never shown to have been retaliated against. She settled her claims. And had they gone to court, there's a very good chance she would have lost that claim. I've also seen her attorneys come out and press or a source for Lively, at least on one occasion, and once Michael Gottlieb, her attorney, one of her lead litigators, say this wasn't just about money, but I actually watched the hearing where the judge asked them why they were using a specific California statute, and they said because they could get more money, more damages. So I kind of call bullshit on that. No doubt remains that the Wayfarer party's suit is the prototypical suit that the California legislature intended to short circuit by enacting Section 47.1. Okay, again, there's been no finding of that. The alleged defamatory statements that formed the basis of the Wayfarer party's retaliatory lawsuit satisfy all elements of privilege under Section 47.1 for reasons that have already been raised to this court. Thus, as the prevailing defendant, Ms. Lively is entitled not just to attorney's fees and costs, but also to compensatory damages, tripled, and punitive damages. Blake's attorneys wrote here, because the factual record has developed further since that time, up to the eve of trial in Lively v. Wayfarer Studios, Ms. Lively respectfully requests leave to file a short supplemental brief of 5 pages or fewer to address any impact of the court's intervening rulings since the 47.1 motion was filed, and to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and cost issues in light of these developments. And this is what the judge just denied. He said, no, we don't need any more briefing at this time. This has been fully briefed since September, by the way. And I do think it's kind of ridiculous that she's still trying to drag this out after dropping her claims. She didn't want to go to court to prove what she was saying. She shouldn't be automatically granted the benefit of the doubt here. The Wayfarer parties did write a short letter back to this, saying after agreeing to a settlement in which she dismissed her 3 remaining claims without the Wayfarer defendants paying a cent of the $300 million in damages she was demanding, plaintiff Blake Lively seeks to leave to submit further briefing. Then they go on here to describe section 47.1b. Then they say plaintiff initially sought remedies under section 47.1 in her March 20th motion to dismiss Wayfarer's complaints, filed in response to Lively's complaint for, among other things, sexual harassment. On June 9th, the court granted plaintiff's motion dismissing the Wayfarer complaint, including Wayfarer's second cause of action for defamation against Lively. The court denied plaintiff's section 47.1 request without prejudice, and plaintiff renewed the motion on September 8th. The renewed motion was fully briefed by September 29th. In her April 11th pretrial statement, Lively submitted that the 47.1 motion should be decided in advance of the May 2026 trial, which would have happened last week. And they point out here, Lively did not request or even suggest that additional briefing was necessary. So they're trying to brief this further now that things have been settled. When the trial was supposed to proceed a week from now, she didn't find it necessary to have any further briefing on this motion. So why now, other than to drag this out? At the April 28th pretrial conference, plaintiff again urged the court to decide the motion before trial, and if the court found that plaintiff qualified for relief under section 47.1, instruct the jury that defendant's lawsuit constitutes retaliation, and then it would be up to the jury to determine whether that caused any damages. This is what the judge did not sound like he was really buying at the pretrial hearing, from what I'm told. They also point out here that she did not request additional briefing on this impact of the court's ruling subsequent to the dismissal of Wayfarer's defamation claim. They point out that Lively's attorneys also did not request additional briefing at that time. So they implicitly acknowledge that the court had sufficient information to rule on 47.1, so why are we briefing this further? Plaintiff does not explain why a week later she believes supplemental briefing is necessary to address any impact of the court's intervening rulings, since the dismissal of the Wayfarer complaint and plaintiff's 47.1 motion, or to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and cost issues in light of these developments. So they point out that Blake doesn't explain why a week later she believes supplemental briefing is necessary. She also doesn't explain how rulings subsequent to the dismissal of Wayfarer's defamation claim could possibly impact or increase the costs. So she doesn't explain how her right to relief under section 47.1 could be affected by subsequent rulings. And they request the court deny further briefing, which the court did. So, all right, guys, I just wanted to give you a quick update on that the judge had declined her request for further briefing at this time. I don't know if that means they could ask for it later or if the judge is just going to rule on what they have. But that's all I got for you this afternoon. So thanks for watching. Don't forget to hit the like button for me because it helps me out a lot. And I'll see you all soon. Bye.